One of the first drug cases I had involved a college student who experienced a bad trip. Somebody put it in the punch at a party, and he didn't know exactly what it was. But when he started freaking out, his friends took him to the hospital. And at the hospital, he got interrogated so they knew what to give him. And consequently, when he calmed down a little bit, a Boulder police officer came in and slapped cuffs on him and told him he was under arrest for illegal possession of LSD. Well, the possession was in his body, but other than that, the logic was he had to have possessed it to have taken it, and LSD was illegal, and therefore he'd committed a crime. Now, this was in I think probably 1970 or thereabouts. And that's when we really still had law rather than statutes and political agendas and things such as that. However, certain things like drug offenses, prostitution, and gambling and prohibition have always been hot issues and have been promoted and backed by various pressure groups to push certain agendas. So the agenda here was drugs are bad, and anybody that uses drugs or possesses drugs or whatever is therefore bad. And some people think they're not bad, and to teach them a lesson, we have to give an example. And by giving an example, we mean putting them in jail. So if you've got a person who's, say, a second or third year person in college, it is better to tag him as a convicted felon and drug offender than it is to be kind or considerate or anything else. Now, the irony in that case is that a large faction of the public was advertising that drugs are dangerous, drugs are bad, etc. But if you're having a bad experience with the drugs, go to the hospital and they'll treat you. And then you had another diehard group that said no matter what, drugs are bad and we have to send a message, and anybody dealing with drugs whatsoever has to be punished. So the policy aspects were conflicting. Now, back then, the judges were not picked from the bureaucracy. The judge I had drawn in that case was retired, or actually wasn't retired. He applied he was an attorney for a bank, a trust attorney, and administered trust funds and things like that. He wasn't really what you'd call a legal scholar, but he was an ardent and active member of the community. And he wasn't a zealot. He was a judge. He wanted to be fair. So the case came in front of him, and I had some motions to argue. And one of my motions was one to dismiss. Now, this defendant's father had been an MD in a north central state in general practice in a medium-sized town. He was very concerned for several reasons as a doctor and as a parent, but mainly he was concerned, as was I, that it's bad policy to arrest people when they go to hospitals for help. Plus, he, being a member of his local medical society, truly believed that it was against the Hippocratic Oath. Now, one of the things happened in this case was the emergency room doctor that treated this kid sent a bill for his treatment, which the county actually picked up. But then he became a witness. He was endorsed as a witness. He was the only one that could say that the person had suffered from LSD and had supervised and was very essential to the chain of custody. Anyway, he charged a fee equal to mine just for being an expert witness in this case, which I thought was ironic. They want the defendant to pay for his treatment and to pay for somebody to testify against him in total violation of the Hippocratic Oath, in my opinion. So I decided to test him on that. Anyway, on the motion to dismiss based on policy, I argued this about the policy of punishing people for getting treatment and treating illnesses, criminality, etc. And the case was dismissed. Now, we had a hard-ass Republican district attorney at that time, and even he conceded that the policy argument was valid. It was a righteous argument, and he had internal discussions, I guess, among the various deputies on his staff whether or not to prosecute the case in the first place. A couple of years later, I get a call from a professor at one of the universities in Texas. And he had a 3-year-old son who was playing on a swing set in the backyard and somehow fell off the swing and must have banged his head. Anyway, became unconscious, and they took him to the hospital. Upon interviewing by the admitting doctor or nurse, whomever, it came up that this professor had a couple tabs of LSD in his dresser drawer. The question was, I think, were there any drugs around? Could your kid taken any drugs? And I think the answer was, well, he couldn't have had access to them, but we did have some in our dresser drawer. Well, immediately the police came and they arrested the professor. And as they were arresting him, the child died. So they presented the case to a grand jury in Texas and returned an indictment for murder. It was felony murder doctrine. Possession of LSD was a felony, and while he was in possession of LSD, a child died. And since there was a death connected to the felonious possession, a felony was committed and death occurred, therefore it was felony murder. Well, thankfully he got out of the state of Texas before they could arrest him. And he came to Colorado and wandered into my office somehow. And in that case, we fought extradition, essentially on the same basis. The problem with a lot of these cases and policy cases, that starting with the beginning of the Nixon administration, they wanted to show that they were tough on crime. And to show you're tough on crime, you have to sacrifice a modicum of humanity. And in my estimation, common sense. And that was what was going on here. Common sense took a second row seat to logic, to policy, to justice. In other words, it was more important to prosecute somebody and impale him on the pike of public relations in order to set an example which may or may not affect the behavior of others. Now, from that point on, more and more prosecutors were saying, let's send a message, this is what we want or that what we want, clearly against the case law. But case law was becoming less and less important, And agendas became more and more important, and laws suffered, which is why we got to the position we did today. Now, there's all kinds of agitation for change, and they talk about a pendulum swinging back and forth, and left and right, and things like that. But the thing that most people don't realize, including most lawyers and judges, is that the pendulum is on a different clock. We no longer have a common law system where we have laws that are acquiesced to and legitimized by majority consensus. What we have now is law from the top down, as in a Napoleonic Code, where a majority says this should be the law, this should be good, this should be bad. They have an agenda for it, and they enforce the agenda because they have the power to do so. And the agenda becomes more important than justice. So you get to the point where, like, for instance, the Supreme Court case came out of Texas several years ago where a person was proven innocent. But the Supreme Court of Texas said, well, it's bad public relations to find somebody innocent and point out the flaws of the trial court. So they wouldn't reverse it. And I think this is wrong. And the problem that I see over the years is you got a lot of people coming up that don't see this as wrong. They think, well, the ends justifies the means. So if we believe this or believe that, then whatever we do to accomplish that is just. It's good. And to hell with the consequences, and to hell with people that get crushed in the process. The whole problem with this thought process is generally the people that get put into the mincemeat of so-called justice and used to be an example are poor. And the poor people don't have anybody speaking for them, and they can't fight back. So the soccer mom mentality takes control, and their kids are somewhat immune from this. But the poor kids, particularly minority kids, are the ones that all of a sudden are used to be the advertisement for the agendas. Thank you.